Welcome to this month's teleseminar. I'm Dr. Peter Weinstein, and I'm very pleased to have a large group joining us today to hear about a very timely topic, an issue that has hit the radar screen of veterinary hospitals, not just veterinary hospitals, but all businesses in the state of California, and this is a California-specific issue. And I'm very happy that we were able to get Thomas Daugherty to join us. Welcome, Mr. Daugherty.
Oh, thanks very much for having me, Peter. It's great to get to talk with you about this major change in employment law.
So let me tell you a little bit about Mr. Daugherty here. Can I call you Tom?
Please do.
From those of us in the Midwest, Tom went to the University of Michigan. I'm a University of Illinois, so we really even shouldn't be talking. At least not sports.
Right. We'll stick to the issues.
We'll stick to the issues. And then he went on to get his law degree, kind of as a second career, but he went on to get his law degree from Loyola University in Chicago. His prior career before law school was actually in theater, which is pretty cool when you look at him as a litigator. Tom litigates and counsels clients in employment law, professional liability, and commercial litigation. And this is probably the most significant point that I'm just going to read from his bio. Particularly in employment law, an ounce of prevention is worth a pound of cure. Seemingly small violations can quickly turn into major headaches, including individual litigation and class action lawsuits. To avoid these problems, Mr. Daugherty regularly counsels employers on best practices, policies, and multifaceted human resource issues. And I was talking to Tom before we got started, and I said, let's consider today's phone call to be a vaccination in an effort to prevent problems, because treatment of the disease is going to be much worse. So, Tom, let's get started. Here's your first challenge, a question.
Okay, sure.
Human resource laws are quite intimidating and seem to change routinely. Surprise, surprise, just like this one. This recent ruling is a perfect example of why one can never get comfortable as a business owner, especially in the state of California, when it comes to employee rights. Let's focus on the current ruling. Can you give us a brief synopsis of where the ruling came from, some insight on the nature of the case, and maybe a little bit of logic behind the ruling?
Sure. The Dynamex case, it arose as a class action lawsuit filed by two individual delivery drivers suing on their own behalf and on behalf of a class of allegedly similarly situated drivers against their purported employer, a nationwide package and document delivery company. And they alleged that Dynamex, the company, had misclassified all of its delivery drivers as independent contractors rather than employees, and as a result, there were multiple violations of the applicable wage order and labor code provisions, and on like that. The court, the issue before the court was, what is the correct standard of classifying workers either as independent contractors or employees? And for years we've gone under the Borrello case, which held that, essentially if the hiring entity has the power and ability to control the manner and means of how the work is performed, along with, various other factors, they're more likely to be an employee than an independent contractor. California, this is a Supreme Court decision. The court discussed that, when a worker is employed as an employee, the business bears the responsibility for paying, federal Social Security and payroll taxes, unemployment insurance taxes, and state employment taxes. They must provide workers' compensation insurance and comply with the numerous state and federal statutes governing wages, hours, and working conditions for the employees. The worker then gets the protection of all these labor laws and regulations. On the other hand, if they're classified as an independent contractor, the business doesn't have to bear any of those costs or responsibilities, and the worker gets none of those protections. Ultimately, the public may be required to assume additional financial burdens with respect to workers and their families should issues arise. Now, the reason this case, is such a big deal is because of the economic impact both on companies and workers. For instance, if workers who should be treated as employees are improperly misclassified as independent contractors, it creates a risk that they're going to be taken advantage of, because essentially the businesses will be pushing their business expenses onto the worker, kind of in violation of the labor code protections. This not only hurts the worker, but also creates potentially unfair competition or an unfair competitive advantage over other businesses that properly classify their workers as employees. The court noted that also federal, state, and state governments have declared that this misclassification of workers as independent contractors deprives billions of dollars in tax revenue to federal and state governments, and deprives millions of workers the labor code protections to which they're entitled. So kind of to drill down to the result of this case, the court basically didn't throw out the old standard because it's alive in some ways in this new standard, but it established a new test for the classification of employees and independent contractors. And it followed basically the law as it is set out in Massachusetts. It adopted this ABC test that's been in practice in Massachusetts for a little while now. Under this test, all workers are presumed to be an employee, and a worker is only properly considered an independent contractor if the hiring entity establishes each part of this three-part test. First, that the worker is free from the control and direction of the hirer in connection with the performance of the work, both under the contract for the performance and, in fact, in practice. Second, the worker performs work that is outside the usual course of the hiring entity's business. And third, that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. So you have to hit all three of those factors and be able to prove those with substantive evidence that this worker qualifies as an independent contractor. They're performing work outside the business. They do this independently on a regular basis, not only for our entity but others, and they're free from our control and direction. If you don't get all three, then they're going to find an employee instead of an independent contractor. So it's a big change in the law, which was much harder to follow in some ways because it was a real balancing test of that right to control with 6 to 9 multiple other factors, and there was no clear way. And the court decided we need a very clear, easy way to classify workers, and this is it. And so it's a major change, and makes it much easier to find employees as opposed to independent contractors. So it's got a huge impact on California employers.
Yeah, it's going back to the original case. I can see this going to be impactful on companies like Uber and Lyft and others, and the both intended and unintended consequences will impact virtually any employer out there. In trying to dumb down the law, I just want to make sure I heard you correctly. It is the responsibility of the employer to prove parts A, B, and C. So if an employee were to, a potential employee, an independent contractor would say, hey, don't worry, just pay me as an independent contractor, it still is the responsibility of the employer to prove parts A, B, and C and make the correct decision. Did I hear that correctly?
Yeah, that's right. The burden is on the employer, And, whether or not the employer or the worker kind of consents to the agreement, the labor commissioner can still pursue things on their own and make findings, independently of any complaint filed by, a worker. And also, while you may have a good relationship with that worker at the beginning of the relationship, things don't always stay that way in that type of situation. And, without some kind of, agreement, and I'll talk about that in a little bit, there are ways to protect yourself in that situation, but relationships can change, and while they consent at the beginning, they may change their mind and say, you know what, I think I am an employee and I'm entitled to overtime, and you didn't give me my meal and rest breaks, and you're in violation of all these laws, and I'd like a payday. So there are a lot of things that can go wrong, and so you want to prepare up front. And so when you get in a questionable situation, you're hiring somebody that wants to be an independent contractor, you might ask yourself some questions. Am I or is the entity going to supervise this worker, direct the worker's activity? Are we providing clients or, patients for this worker? Do we provide the equipment used by this worker? Those should go to that first control element of the ABC test. Next, does the worker perform services that are a regular or necessary part of my business operations? Does the worker perform services that are similar or comparable to my other employees? If so, that's probably services provided in the normal course of operations for the business, another finding that you'd have an employee as opposed to an independent contractor. And then finally, does this worker perform services for other clients other than my business? Or does this worker have a business license? Is this worker incorporated in some way in order to provide the services that she or he is providing? So that goes to are they established as an independent business? And you've got to hit all three of those to find an independent contractor.
So before we dive back into the details a little bit more, most businesses, employers, we're classifying workers as independent contractors for a time and money savings. I mean, if you don't have to make them an employee, you don't have to fill out all the paperwork and everything else. You hand them a check, they hand you a receipt, thanks, and you're out the door. But if we start to look at this from a litigation standpoint and from a cost standpoint, should they be involved with a lawsuit? And I'm sure you've had to deal with some or of some of this nature. Can you give us an idea of how much time it takes for the employer in terms of preparing for the lawsuit and in the lawsuit itself, and what the potential fees, costs, fines? Okay, here's your opportunity to hit the fear factor, Tom.
Well, there's plenty of ammunition here, I'm afraid, for employers. In part because if an employee is successful in an employment lawsuit, there are multiple provisions of the Labor Code which award reasonable attorney fees for a prevailing plaintiff. So the employer, if they're defending the lawsuit, they're going to pay their own legal fees, and if they lose, they're going to pay the plaintiff's legal fees. So you've got two sets of attorney's fees, and inevitably the plaintiff's fees are going to be a lot higher than the defense counsel's fees, just because that's kind of how these things go. And if it's a long, drawn-out litigation, that can range anywhere from, depending on how it resolves or where it resolves, that can end up between $300,000, or if it's a big extended class action, $1.5 million. So there's a huge range in attorney's fees alone. But then you get into all the possible claims for misclassification. And I'll kind of address a class action. And so in a class action, it's not just one employee, but it's every employee that you've had in this category for the last 3 to 4 years. If it's they can make a claim for unfair business practices under the Business and Professions Code, which extends the statute of limitations back 4 years. So you've got a potential 4-year look back for each employee. And the types of claims that they'll bring, there's first a misclassification claim. Then, assuming they're correct in that, they should have been an employee, they'd be entitled to all unpaid overtime, unpaid wages for all time worked. For each meal and rest break that they can prove that they missed, there's an hour of additional premium pay that will be awarded. They'll be entitled to wage statement violations, reimbursement for all business expenses incurred, and that would include mileage if they're, doing house calls or, having to drive for business, or, equipment that they've bought as in, required for the business. There would be violations for failure to withhold, taxes and things from their wage statements, on their wage statements. Unfair business practices, fraudulent concealment, failure to provide 1 day of rest per week, waiting time penalties for anyone that's been terminated or has left, failure to maintain personnel records. I mean, the list just goes on. So it's, then say your average, you add all that up, and for each individual employee, it might be in the ballpark of, who knows, $60,000. But if you've got 50 employees, you multiply 50 times 60,000, and you're suddenly in the $3 million range, and that's in the violations and penalties. Then you add on the attorney's fees that we talked about, another, $1 million, and suddenly it's like you're bankrupt. So that's the fear that this type of lawsuit can bring, and that's why a lot of them settle, for something much less than that, but still significant amounts early on in the litigation, as opposed to getting all the way through to a trial of that type of action. So there's a lot of potential risk to employers or to business owners for continuing to use independent contractors, especially under the new rule, where it's so easy for courts to find, yep, that person's an employee. And not only that person, but everyone that works like them that you've used in the last 4 years.
Okay, so now that everybody has picked themselves up off the ground or gone to grab a beverage of choice at lunchtime, let's talk about some cases and some situations. The most common workers that fall into this issue for veterinary practices are what are called relief or per diem or locum veterinarians. These are veterinarians that come in for a few days every once in a while to give the veterinarian a breather or fill in some gaps. Now, some of them come in and they're just individuals. They may or may not have incorporated. Some are S corps, some are just running as a small business. You mentioned some things in the questions about whether they're incorporated or not. What would a hospital owner need to look at to determine if they qualify as an independent contractor, if they're incorporated versus if they're not incorporated?
Sure. The issue with whether or not a worker is incorporated, that can provide some protections. And honestly, the Dynamex case was not clear on how this is going to fall out in California. But if we take a page from Massachusetts law, under Massachusetts law, which on which we modeled this new law, or the California Supreme Court did, they allow for business-to-business contracts for services, and so the worker is still presumed to be an employee, and especially if they're performing services that the business ordinarily performs. So they're going to be found an employee. But what you can do in a situation like that, if they're incorporated, is to put it in writing. Say, this worker, or this we'll call the Workers Incorporation Relief Corp. So if Relief Corp is they're agreeing to provide employee or employees to the hospital or clinic, and you put that in writing, and you make it so that Relief Corp's responsibility, they're responsible for providing all wages and payments to the employee of Relief Corp, and in return, the hospital clinic is going to pay Relief Corp a fee. So Relief Corp then gets all the, and they're required to provide workers' compensation insurance and all these other things. And maybe most importantly, you require Relief Corp to indemnify and defend the hospital or clinic in the event that there are any employment-related claims made out of this agreement or arising out of the agreement or the arrangement. And that way, you've got some, protection because that relief vet is still providing services that are, in the usual course of the hospital or clinic, they're an employee. And in California, we do have joint employer liability. You can have more than one employer under the law. So you want to make it very clear that Relief Corp or whoever that entity is, they're responsible if you're not hiring them directly as an individual employee. If it is just an individual, you want to look at the ABC test. Are they free from the control and direction of the company? Are they providing work outside the usual course of the operations? And are they customarily engaged in an independently established profession? If they don't make all three of those, then you should hire them on as an employee, whether that's a temporary, seasonal, or permanent employee, part-time even, to protect yourself and provide all that you need to provide under the labor code and other applicable provisions.
So that last part, that C part, which talks about doing work independent of the business that they're going to be an employee or an independent contractor or something. What was the specific wording on that part C?
Sure. The worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. So if this relief vet is, an established kind of independent vet, whether they're incorporated, or acting independently, they need to be working for multiple other entities or providing services of the same nature, veterinarian services, for other clients, separate and apart from, for the hospital or clinic that's hiring them. Okay.
The other employee that commonly falls under this, and I'm just speaking from personal experience, are groomers. The basically the individual who makes poodles look like poodles and schnauzers look like poodles. In my experience, most groomers are not S corps. They're not incorporated. They're just individuals coming in with their own equipment, sometimes on their own schedule, to provide a service in your physical location. And they may or may not work at other locations as well. They may be at yours exclusively. In looking at the A, B's, and C's, they're going to be very hard to pass the sniff test, aren't they?
Yeah, I think so. I think the Dynamex court made clear that this was intended to be a very broad and encompassing new standard to make many more people employees than independent contractors. And even though the groomers aren't, providing veterinarian services, they are providing services to animals, which is what the hospital or clinic provides. And so the court, they gave a couple of examples of what might be independent contractors and what might be employees. And I'll just read from the opinion very briefly. For example, on one hand, when a retail store hires an outside plumber to repair a leak in a bathroom on its premises, or hires an outside electrician to install a new electrical line, the services of the plumber or electrician are not part of the retail store's usual course of business, and the store would not reasonably be seen as having suffered or permitted the plumber or electrician to provide services to it as an employee. So not in those professions for the retail store, plumber, electrician, independent contractor. On the other hand, when a clothing manufacturer company hires a work-at-home seamstress to make dresses from cloth and patterns supplied by the company that will thereafter be sold by the company, or when a bakery hires cake decorators to work on a regular basis on its custom-designed cakes, the workers are part of the hiring entity's usual business operation, and the hiring business can reasonably be viewed as having suffered or permitted the workers to provide services as employees. So even though they may not be performing work on premises, or they may just be coming in occasionally to work on specific aspects, those people would be found to be employees. So I think similarly the groomers, because they're providing services that are part of the usual course of business for the hospital or clinic. They're working on animals. That's what the clinic does. They'd most likely be found employees. The safest route would be to hire them on as employees or require them to incorporate but if it's not in their nature to form their own business, then you may want to bring them on as an employee.
By the way, the law went through the Supreme Court. It was announced earlier this year. Was it then? Did it go into effect immediately, or was there an expectation from a deadline standpoint that it would go into effect, or how does that work?
Sure, good question. Court cases are different than statutes in that court cases are basically effective immediately upon the issuance of the opinion. Once it's published and it's out there in the public, it's effective. Whereas opposed to, laws enacted by our legislature, you know that they're coming ahead of time. The laws get passed maybe in October and become effective January 1st. So you've got that quite a bit of lead time to make the changes necessary. Not so with the Dynamex opinion or other court cases that make kind of major changes in the law like this. There is one issue with the Dynamex opinion in that it was silent. The court did not say whether it would apply retroactively or only going forward on a prospective basis. And so before the court right now, there is a motion filed by the defendant, the employer, to make it only prospective going forward. And the argument there being, hey, for years and years, California companies all across the state have been complying or trying to comply with this one standard, and now you turn it on its head and make it so it's almost impossible to comply with for a lot of the independent contractors out there. It wouldn't be fair. There'd be a major due process violation. This is a substantive change in the law and should only be enacted going forward. And that way. The California employers are not going to be instantly liable for 4 years of penalties for all the independent contractors they've used, but they do need to make changes to comply with the law as soon as possible going forward.
I've got one more question, and then I want to open it up to see if anybody on the phone has questions. So
sure.
Those people who are on the call, if you want to raise your hand, hit *2, raise your hand if you have a question, and I will unmute you. But in the meantime, a law firm might hire an outside litigator to come in if they don't have an expertise in that case, in that type of law. A veterinary hospital might bring in an expert to do a surgical procedure, perform acupuncture, do internal medicine. These are usually have an advanced degree. They're boarded in those skills. They would come in, perform the procedure, and then leave. Any thoughts on where they fit on the independent contractor spectrum?
Well, it's going to be done on a case-by-case basis. If the lawsuit, if in the example of the law firm, if the law firm didn't do litigation and they were getting sued and they hired an attorney to defend them, that might be an independent contractor. But if they're providing litigation services to others, and in the instances of the other specialists in the veterinary fields where they're providing, specialized, treatments that the hospital or clinic doesn't ordinarily or have the expertise to do, whether it's acupuncture or, a specialized surgery or, providing x-ray. I still think those are most likely going to be found to be employees because they're providing services in the normal, ordinary course of operations for the business. Even though they may be established separately, they might hit the C test and the A test, but if they miss any one of them, and this would most likely fall into the B test, they would most likely be found an employee. But again, we'd look at that on a case-by-case basis. But like I said, the court made it very clear this was supposed to be a very broad, encompassing change in the law to provide much broader protections for workers in California.
We got one question so far, Tom. I'm going to unmute somebody who is on a cell phone from the 714 area code, says they're in Anaheim. Go ahead if you raised your hand.
Yes, my question is, in general, because most of the relief veterinarians or relief technicians that we use are going to be performing veterinary work, then the first checkpoint would always be no, because they're always performing the duties that we do in the hospital. So right off the bat, they would not get number one. That's how I'm interpreting it. Is that correct?
Number one would be they're performing. They're free from the control and direction of the hiring entity. That's the first test. The second test is whether they perform work outside the usual course of the hiring entity's business. So it sounds like you're talking about the second test.
Number two, I'm sorry, yes.
Yeah, that's fine. And I agree that, relief vets, if they're providing services that your other vets provide on any kind of regular basis, they're going to be part of your regular operations, and they'll be an employee as opposed to an independent contractor.
Okay, and then what about like consultants? So if you come in as a veterinary consultant and you perform veterinary practice management duties that a manager could perform, and you have your own business, would you then have to be on like an employee, or could you still be a private business that you work as a consultant for multiple hospitals, but you're performing, veterinary payroll, or you're performing manager duties or things that go on in the practice? How would that change?
That's a good question. It sounds like, so they're not performing the active services, animal care and that type of thing, but they're part of the necessary operations of the business? Yeah,
there's a lot of consultants that talk to owners and help them with, maybe things they're struggling with, or they help fix things in the hospital, but they'd be performing potentially management duties that a practice manager could perform, or even a practice owner could perform, but not on a everyday, day-to-day basis. They may have 10 different clients that they work with doing this.
Sure. I guess I would, it's hard to make generalizations based on that description, but I think you're going to find they're more likely than not going to be found to be an employee because, they're providing operations that are necessary as part of the usual course of the business, whether it's managing employees or actually performing the on-the-line work that the vets provide. One thing you might do is if they are set up as, a separate entity, work with one of those kind of business-to-business agreements, contract for services, and make it very clear that they're an employee of their own corporation and not of your entity.
So they can put that on their, like, LLC or whatever. They can say, I'm an employer of my own company.
And honestly, there's no guarantee that is going to be sufficient for the California courts, but the Massachusetts courts do allow that kind of business-to-business contracting for services, and they specifically said that if you've got a worker who's legitimately operating their own business as providing that type of services, they shouldn't be included in this type of classification issue. They should be allowed to operate in their business as an independent contractor, a contractor for services. So, you'd want to have a very clear written agreement between the two entities, establishing all the the terms of that and the defense and indemnification if there is any claim for employment-related issues out of that.
Okay, thank you.
All right.
Yep.
We got a whole bunch of questions. I'm going to unmute number 2, who's in Simi Valley, American Veterinary.
Hi. Can
Hi.
you hear me?
Hello.
Yes.
Yep.
Hi. So I have a couple of questions. Are relief or employees or 1099s or even people who come in as incorporated or an LLC, are they then entitled to paid time off, and how are we supposed to handle that? And what if you only use them once in a blue moon? I mean, or once a month, or that's one question. And then the other question that I have is, can an incorporate or an individual be considered as a 1099, or are they incorporated?
I'm sorry. Can you elaborate? What's your second question?
Can an incorporate individual be considered a 1099 employee, or an LLC, or a corporation? Like, how are they classified?
Sure. So the question is, can a person operate a business and provide services through that business?
Yes.
Okay. We don't know for sure because this is a brand new case and there haven't been other appellate opinions interpreting it yet, but if we follow the law that Massachusetts has established relating to this, and California modeled this new standard on that Massachusetts law, under those cases out there in Massachusetts, that type of agreement is permitted and would not be subject to this independent contractor test. You could have a business-to-business agreement for the provision of services, and that person could operate and provide services to you and multiple other clients under the umbrella of their business.
Now, are they entitled to paid time off?
Well, it would depend on your agreement with them. Employees are entitled to paid time off under the paid sick leave laws, whether it's the state of California or if you have a local municipality with a higher level of paid time off. If you hire employees, they must be accruing, either provided a lump sum accrual at the beginning of the year of paid time off, which they can then use, or they can accrue as they work and earn. So yes, any employee you would have to provide paid time off for. And whether you use, you can have workers that work part-time, that work occasionally. You can have employees that do that, but you need to provide them all the protections that employees are entitled to under the Labor Code.
But not 1099 employees?
Well, you're saying a 1099 employee. There's no such thing, really. You're either an employee or you're an independent contractor. If you're contracting with another entity for services, the contract is going to determine that. And as I've suggested, we don't know for sure how the courts will rule on that, but following Massachusetts law, that looks like that'll be permitted. And the way you want to structure that, first of all, talk to an attorney, have them draw it up for you, and that's certainly something we can provide. But then you would want to have the workers be an employee of that entity, the employee's entity, and have them indemnify you for any claims for employment-related issues that might arise out of that.
Is there a time frame as to when this is going to be effective in California? Because I know
it is effective right now. As soon as the court case came out, the law is in effect. And as I mentioned to Peter, the question is whether it will be applied retroactively or only on a going forward basis. So right now, the standard is applied. And, you know, if you're still using independent contractors and you have questions about it, anything specific, you know, feel free to contact me and we can talk offline. But you want to make changes to comply with the law to the largest extent possible as soon as possible because it's already in effect.
All right, let me go on to another question. I'm going to unmute somebody with a 562 area code. Says you're in Alamitos. Go ahead.
Oh, yeah. I was just wondering if this applies to businesses and corporations that are based out of California, not in the state, out of state. But they they have employees or 1099s in the state of California.
Yeah, if workers are working in the state of California, their employers have to comply with California law. So this would apply to those type of workers.
Okay, thank you.
Sure.
Thank you. One of the things you said on the prior answer that I thought was great and needs to be understood is that you're either an employee or an independent contractor. There is no gray. Is that correct?
That is correct. Yeah,
okay.
And the new law makes it very simple to tell. You know, if you have questions, you know, if you're confused about it, but you're right. There is no gray. There's no kind of straddling both categories. It's one or the other.
Right. All right, a couple more quick questions. Huntington Beach Pet Hospital. Go ahead, HB Pet Hospital.
Yeah, Andy Lewis here. So
hey, Andy.
Just trying to maybe simplify this a little bit. First of all, if I'm understanding, the best case scenario would be the relief veterinarian, if they are operating as an S corporation, then the first thing we absolutely should be doing is rewriting a contract to indicate we are specifically hiring the S corporation to provide an employee of their own, and then, of course, having the indemnification clause in there that any issue were to come up is essentially between their employee and their corporation and has nothing to do with the hiring corporation. Is that fair enough to say?
Yes. That's essentially it, and you know that's with all the caveats. You know, the California courts may come up with something different, but that's kind of the best advice that we have right now. You want to make it as clear as possible, and generally indemnification provisions are enforceable. You know, as long as it's you know, made knowingly, and you know they have time to consult with counsel and all of that stuff.
And second question actually was pertaining to what the other person was just asking. If I understand correctly, if it is an S corporation that you are hiring, whether it be a regular relief veterinarian or if it was an orthopedic surgeon coming in, there is no need for the hiring hospital to file any 1099 at all on their behalf. If they're incorporated, you write them a check to their corporation and you're done. There is no 1099 at all.
Well, I'm not a tax attorney, so I'm not going to get into the nuances of tax law. But the payment would be to the corporation, and how you would report that payment to the corporation, I would consult your tax consultants.
All right, Andy.
But if you have the agreement such that they're responsible for payment to the worker, then you're right. There is no direct payment to the employee or the individual providing the services. The payment is to their S corp.
Right. Thank you.
Yeah. So they should have an EIN that they would also be using on the 1099. So I frequently get paid to my corporation with a 1099. So our next call I'm going to unmute is actually it's a Charlotte, North Carolina 704 cell phone.
Hello, can you hear me?
We can.
Oh, thank you. So my question is, I'm someone who works full-time, and I do provide relief services, a couple times a month or so, and have been getting just a check every time I work, and that's been great. I get 1099 at the end of the year, and I was able to, report my expenses under that. But my tax guy just informed me that starting next year's tax return that there's no employee business deductible that we can use. So all the expenses incurred if you work as a full-time or part-time employee is not going to be able to be tax deductible. That means I can either keep working as 1099, which seems like that option's gone, or then I need to have a S corp or incorporated company in order to report my expenses. Is that right?
That's a little beyond the scope of what I'm comfortable, talking about as far as how, what the tax ramifications are for this. But you're right in that you need to either be an employee or, providing services through an S corp or something like that, if you're providing relief vet services. And that's my general understanding of the law is that, these kind of individual ability to write off business expenses as tax deductions, that's kind of gone away now under the new tax law. Yeah. But as I said, not a tax attorney, so okay. I'm not going to get into the nuances of that.
Okay, I think it might be a good idea. We could actually do this down the road is to bring in a tax attorney to talk about the CPA's thoughts on these 1099s and business expenses, but I think Tom is right. This is probably best left for those people with CPAs and not JDs.
Yeah.
So thank you. Final question, and then I've got one that came in online, is from a number in Sun City, a 951 number, not just for pause. Are you there?
Hi, can you hear me?
Yes, go ahead.
Okay, hi. Yes, I think most of the questions have been answered, and I think, yes, a lot of us, I'm a recent new owner, and I'm actually about to try and use some relief veterinarians. I think most relief veterinarians are unfortunately going to get caught out by Part A because they are working under the control of us, so they will have to become our employees. But I guess it was along the lines of the 1099 thing. So I'm assuming now when I am searching for my relief veterinarians, I am going to need to have them either be some kind of S corp or something like that. I mean, I literally have a relief veterinarian coming in on Tuesday and Wednesday next week, and I'm pretty sure most of the relief veterinarians I use are not incorporated. I know my specialty surgeon is, that comes in and performs surgeries that we just can't do here without him. But I know most of the relief doctors that I use in the area aren't set up that way. So I'm assuming that is something that now as owners we are going to have to be very prudent about, kind of figuring out how to make them our employees, because of course then the write-offs for them aren't as good, and we pay them more because they don't get the benefits, but now they are going to. I just want to double-check that I'm correct in thinking that way.
Yes, it's a major change. People that have been depending on independent contractors for a long time are suddenly facing this, having to make them employees, and how do I balance the cost of what I was paying them versus what I can pay them now, because I have to pay all these other issues, do withholdings and the taxes and employee issues and workers' compensation and all of that. So yes, it's a major change. You can try going the route of hiring them through an S corp, but if they're not, you would want to hire them as an employee if you're going to use them to provide services.
Yeah, this is going to be a big deal for a lot of relief veterinarians, I feel like.
Yeah.
Well, and it's going to be a lot of work for hospitals too. I think this has got a lot of moving parts that will be impacted, and I think my bottom line message to anybody who's been listening is, don't be the first test case in the state of California. All right. So, Tom is your vaccination. By the way, I'm going to go ahead and mute you, my friend in Sun City. Tom is your vaccination today. He is giving you an immune response that will allow you to decide how you want to handle these situations. I think, Tom, it's going to be very important that people know how they can access you if they either want to engage your services or have subsequent questions. So what's the best way for somebody to reach you?
Sure. Email or phone is probably great. My phone number is 619-239-8131. That's 619-239-8131. And my email is tdaugherty, that's TDAUGHERTY, at Klinedinstlaw.com. And that's KLINEDINSTLAW.com.
Tom, all I can say is the last half an hour plus have been eye-opening regarding changes. I think many veterinarians have been hiding under a rock, trying to avoid being noticed in this issue. I think the number of people that have been on the call and the number of questions that we had indicate a serious concern. And,
sure.
We may want to revisit this again later in the year as more water gets under the bridge and more information is learned. But I can't thank you enough for sharing your time and expertise on this call and with our members. And, I thank you for trying to help us wade through a very challenging, new, not so new, but just a new interpretation of the law. So, Tom, thank you so much for your time today. And we look forward to having you join us again next time. So thanks to all of you, and again, thanks to you, Tom.